Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan, where I've been practicing law for 26 years in the fields of consumer protection and lemon law. I often write about this stuff for places like roadanddirect.com, and I've written a few books. I just got over a seasonal malady, cold or the flu. So 1 week of cold medicine, etc. in my body. I'm just getting over it now. We'll see if we can make it through the entire podcast without coughing. I should have recorded this yesterday. I'm recording it today. I think I've got it on my system. We'll see. If you're watching the video and there's a horrible edit 15 minutes in, that's what happened. But we'll see if I can make it. Today we're going to talk about what happens if someone sold you a previously wrecked car. Someone sold you a previously wrecked car. This is a call I get quite often. In fact, I got one this week, which inspired this podcast. And it's an extremely common situation, both from dealerships and from individuals. So I'll give you the example that I think is the one that would be most vexing to the average person. Let's suppose you're driving down the road one day and you see a car for sale by the side of the road, private seller, and it's a guy. You walk up there, it's an expensive late model car. The guy goes, yeah, I paid cash for it. I own it outright. I'm the original owner, bought it brand new, drove it for a while. Here's my service records. Great car. It's just time for me to move on. So you walk around it, kick the tires, slam the doors, take it for a test drive, but you do not have it professionally inspected, despite the warnings you've received numerous times from people like me on the internet. And turns out, yay, looks like a good deal. So you buy the car, give the guy the money, get the title, do everything else right, bring it home, wash it, wax it. Hey, the thing looks great. You decide to take it to the dealership for a little bit of work, oil change maybe, and you decide to do that one at the dealership for just the fun of it. And they put it up on a hoist, and the first thing they say is, oh my, this thing's been in an accident. And it's startling how many people I hear from who say, Steve, I bought a car, and the first time I brought it someplace, they put it up on a hoist, they said, it's been in an accident. Okay, so the number one takeaway from all of this is, if you ever buy a car, before you buy it, either put it up on a hoist yourself or climb underneath it to see what someone else is going to point out to you later when you bring it in and put it up on a hoist. Because apparently a lot of this stuff is painfully obvious to the naked eye to anybody who's underneath the car. It's just that so few people are willing to get their hands dirty, so to speak, and actually climb underneath the car that they're looking at when they're shopping for cars. So here's the thing. You bought the car you didn't know, now you know. So we got to back up, because I have people say, Steve, can I sue the person I bought the car from? Now, I will tell you, this varies wildly from state to state, which, by the way, is a phrase I write so often in emails. I wish I had a single key that I could just press that would just type the phrase, these laws vary wildly from state to state, because I get a lot of people who email me and also call my office from other states. And they'll say, Steve, I got a question for you. I'm in Iowa, I'm in Texas, I'm in Idaho. And I say, I'm really sorry, I don't know the law there. They say, well, can you tell me what the law is in Michigan, and maybe it's the same here? And I said, I don't even want to go there because these laws vary wildly from state to state. So here's the thing. The first question you have to ask before you even address the legalities of it is you have to understand the facts. You bought a car previously damaged and repaired, right? The question is, did the person who sold you the car know about the damage? Because there's possibilities they didn't. So for instance, you buy the vehicle, it's got damage. It's possible that the person who sold it to you was in an accident, had it repaired, and sold it to you without telling you. Okay? It's also possible that the vehicle was damaged on the dealership lot before they bought it, repaired by the dealership who didn't disclose it to them. As I've pointed out previously on this podcast, in some states like Michigan, that's legal as long as the repairs are below a certain amount, and they almost always are. So a vehicle can have pre-delivery damage done and repaired at the dealership and then sold to the original purchaser without disclosure. So if that person then sells the car to you, they might not have known, and they certainly weren't even behind it. In fact, they were a victim too. They just didn't know it. Okay? Assuming there's a thing to be victimized here. Second of all, here's the other thing. It's also possible the vehicle was damaged before it got to the dealer. It could have been damaged in transit to the dealer, which the dealer would know about, but they didn't have to disclose, like I said. Or it's possible that the vehicle was damaged at the manufacturer. And I've actually heard stories about vehicles that get damaged coming down the assembly line, and something happens at the last minute as it's about to roll off. They don't scrap the car because it's got a dent in it. They just, fix it, ship it off to dealership as brand new. So the first question you have to find out is, did the seller know about this? And now, obviously, you could ask them, but I don't know if you can trust them or not. They might not even take your phone calls at this point. It's funny how that works. Once they got your money, they don't want to talk to you. But you can always pull a Carfax and see if Carfax or equivalent has the information for you. So it's possible that if the vehicle was in an accident and the guy you bought it from is the one who was in the accident and had it repaired, it's possible that repair will pop up in Carfax. Possible. And obviously, if it pops up in that time frame and you say, hey, this guy clearly knew because he was the one in the accident, he was the one who got it repaired, he must have known and he did not tell me, okay? So that's an important thing for you to find out, okay? But here's the thing. You say, Steve, let's suppose, for instance, that the vehicle was damaged catastrophically at the dealership, okay? Dealership damaged catastrophically, repaired, sold to my guy who then sold it to me, okay? Now, it turns out that for whatever reason, this has come to light and the car is horrifically devalued by this. Because anytime I go to sell it, I'm going to have to say, by the way, it was in an accident. It wasn't my accident. It was in an accident. The vehicle's worth a lot less money. Assuming that that's true, there's something you might be able to do, but it depends on the state. And this, again, like I said, is going to vary wildly from state to state. Because here's the deal. What we're talking about here, for the most part, is common law. Okay? The common law. And common law, for those of you who don't know, is the basis of most of our laws, at least the origins of them. Many laws in America now are defined by statute. That is, that there's an actual law book someplace that defines what the law is and says, here's what you got to do. But even a lot of our statutes follow the common law or mirror the common law. And at common law is where you get a lot of things like the rules of contract, the rules of fraud, the rules of misrepresentation, and so on, negligence and other torts, okay? And so when we're talking about the failure to disclose something to you in a transaction, you're talking about either fraud or misrepresentation. And again, varying wildly from state to state. But what you really basically need to know is this. And again, I'm going to really thumbnail this. So the attorneys in the audience, please shift gears here. I'm not speaking to other attorneys or a law class here. I'm speaking to lay people. Fraud, generally speaking, is where I make a statement to you. You and I are involved in a transaction. I make a statement to you that's false. I know it's false. I intend for you to rely upon the statement to your detriment, to my gain, okay? So I sell you a wrecked car. I know it's been wrecked, and I lie to you, and I say, this car's never been wrecked. And I know that you'll give me more money believing the car not to have a wreck history, and I'm going to profit from that, okay? That's fraud if I do that, okay? But the problem with fraud in most states is you have to prove fraud very specifically. You've got to prove that I knew what I was saying was false, that I intended to hurt you with it, that I did in fact hurt you with it, and that I benefited to your detriment. It's tough to prove a state of mind, and you can do it, but it's tough to do. The other thing that you can often do is go after somebody for misrepresentation. And misrepresentation is, like I often tell people, it's a step below fraud. Because misrepresentation means that it's possible for you to defraud me, or somebody to defraud me, by simply failing to speak, or slightly less than the level of fraud. So, the best example is you walk out, you look at the car, you're walking around the car, and you go, I'm looking for a car that's never been in an accident. And I simply don't say anything. I keep my mouth shut. You walk around the car and you take it for a test drive and you climb underneath it, but you don't climb underneath the right spot. You miss the damage. I'm fully aware of it. I'm just standing there with my mouth closed. And that would be silent misrepresentation, because I would have a duty to speak, to tell you something. I know you want to know this. You would want to know this. And if I don't tell you, it's going to benefit me to your detriment. It's going to cost you. It's going to benefit me. So I am silent. And silent misrepresentation is likewise a common law cause of action in many states. So if you can prove that I had this knowledge in my head and I chose not to share it with you on purpose, okay, you might be able to come after me for that. Okay, so that's misrepresentation. It's like I said, a step below fraud, kind of. So fraud is where somebody actively lies to you. This car has not been in an accident when it has. Misrepresentation is where I just simply keep my mouth shut and don't mention the fact that I know it's been in an accident. And so if you have a situation like that where the vehicle's been in an accident, seller knows and doesn't disclose or lies about it, then you might have a common law cause of action. Okay, so you say, great, this is what I'm looking for. I'm looking for a cause of action, I think, right? Cause of action means you can sue somebody. Okay, so when you have a lawsuit, it's called a complaint. And each count of the complaint after the general allegations, where it'll say fraud, misrepresentation, lemon law, breach of contract, whatever, those are different counts. Those are different causes of action. And in your state, most states have got fraud. Most states have got misrepresentation. Some even have silent or innocent misrepresentation as well, and so on. But generally speaking, those are the causes of action. So here's the thing. You find out you have a cause of action against somebody because they actively lied to you, sold you a wrecked car without disclosing, or they failed to speak when they should have, and your state has a cause of action for that. The question then becomes, what are your damages? Okay? And I always tell people, and I used to teach law school, and I would tell my students this. I'd say, for you to have a valid claim that's worth pursuing, you need to have both a cause of action, liability, and damages. Because it's possible someone can break the law without harming you. It's also possible you can suffer huge, huge damages, but there's nobody you can go after because there's no cause of action. Okay? So here's, let's suppose you find out the vehicle's been damaged in an accident without disclosure to you. Well, you've got to find out what that's worth. Okay? So you find out what your damages are to see if it's worth pursuing. So again, if let's a few years ago, many years ago, I bought a car. I've mentioned it on this podcast before a couple of times. This is before I became with my Explorer fetish. And my brother Dave came out and looked at the car with me, and we were walking around. He goes, "Oh, by the way, Steve, it's been in an accident." And I said, "You're kidding me." I go, "The dealership didn't tell me that. I was buying a car from a dealership used." And he said, yeah. And he showed me, we popped the hood, and he showed me a couple of little indications the car had been in an accident. But it had been fixed properly. He said, it's been fixed. He goes, they did a good job on this. He goes, the only reason I spotted it is because my brother Dave did body work. He goes, I spotted it. I'm an expert. He goes, no one else will spot this unless they look at this right here. So he spotted it. I wouldn't have spotted it without being pointed out to me. And I wound up negotiating the price a little better. But the point is, the damages there were very, very small. Didn't affect the drivability of the car. Didn't affect the resale value of the car, at least not by much. It was a very, very minor little, literally, fender bender. Front quarter, I guess. So I bought the car. But the point is, the damage there would have been very, very small. If they hadn't disclosed that to me, and I asked him, has this car been in an accident? Let's assume that the guy lies. He knows. And he says, no, it's never been in an accident. If I bought that car, it's only devalued a couple $100 by that fix and then good repair. So the damages might not be that large. So when someone calls me, it's often an emotional thing. I feel like I've been ripped off. The guy didn't tell me the vehicle's been in this monstrous accident. And don't get me wrong, I've seen some vehicles that were damaged beyond repair and then repaired that didn't work. And my favorite example is I actually had a client once who had the two cars sawed in half. He bought a car. A couple months after he bought it, he couldn't get the doors open on either side, and it took a little detective work to discover that if you popped the hood and looked around where the firewall on the vehicle was, somebody had sawed the cars in half at the firewall. And they took a front end off one car and the back end off another car and stuck them together and welded them with welds that only lasted a couple months. That's a vehicle where the damages were so catastrophic the vehicle could not be repaired. And failure to disclose that obviously results in damages because that car became literally just a gigantic paperweight. So the question is, are your damages the type I had that are de minimis or the type the other guy has which are catastrophic? Because if you've got damages, it might be worth pursuing. So in case you're following along at this point, you realize I'm doing like a flow chart here, okay? So you find out, do you have a cause of action? Who is it against? And then, do you have damages? And then if you've got damages that are sizable or worth pursuing, then the question is, can you get an attorney to take your case? Because at this point, the flow chart hits a juncture, fork in the road, I think. And the fork in the road is this. You could sue them in small claims court. Depends what your jurisdictional limit is. Some states are 5,000, some states are 10,000 now. But you can sue them in small claims court if you think you can make out the case that, yes, this person lied to me or they failed to speak when they should have. They withheld information from me, whatever it is. And then you have enough damages to make it worth your time to go to a small claims court and try to sue them. If you don't think you can do small claims court, you can, of course, hire an attorney to do this for you. But here's the tricky part. And this is why I don't do a lot of these cases. In America, we've got what's called the American rule. And of course, that makes sense. That's where we live. But in other countries, if you're forced to sue somebody and you win, they have to pay your attorney fees no matter what, as long as you won. And in America, under certain causes of action, both sides pay their own attorney fees regardless of outcome. And I have often spoken about how the lemon law has what we call a fee-shifting statute, a provision where If I sue a manufacturer under the Lemon Law and they are forced to buy my client's car back, they've also got to pay my attorney fees. That's how most of my clients can afford to hire me. But if there's no fee shifting provision of a statute, that means you've got to pay your own attorney fees. So you call up an attorney and say, hey, I got this car, undisclosed damage. I can prove it's fraud. It's $5,000 in damages. The attorney's going to say, how are you going to pay me? And you say, what do you mean? He says, well, it's going to cost $5,000 just to go to trial. Trials are expensive and long and take time to prepare for. Do you really want to expend all that money trying to get $5,000 back? And some people say, well, what about a contingency? And I say, well, 1/3 of 5 is 1.666. So if I'm going to get $1,600, that might not be worth going all the way through a trial for, So it depends on the amount of damages and whether or not it's worth pursuing from the perspective of an attorney. So I've told a lot of people who call me and say, look, it sounds like you've got a decent case. If you can prove that, take them to small claims court. But of course, someone buys a Corvette or some, high-end thing and it's been wrecked, not disclosed, and it turns out that somehow it makes sense. It might be worth pursuing because it might be, if you had a $100,000 claim or $200,000 claim, yeah, that'd be worth pursuing. And some attorney might take that case. But the run-of-the-mill undisclosed damage case, most attorneys won't take those simply because it's not worth pursuing and you'd wind up paying the bills under the American rule. So what I tell people is this. I hate to do this. The best cure for this is prevention. Try not to buy previously wrecked cars. If you can, pull the Carfax or equivalent. If you can, get the vehicle inspected. And if you can't get it inspected, climb underneath it yourself and be sure you pop the hood. And what you're looking for is sheet metal that looks funny. Pop the hood and look where the fender's attached and look down those rails. Are those rails straight? Do both sides look the same in terms of finish? Or is one side freshly painted? Does one side have overspray on it? Look where the radiator mounts. And look there, is that straight? Does that look like it's the same patina as the rest of the interior of the engine compartment? Climb underneath the car, look at the rails. Look, are they straight? Is there rust on one side? Is there rust on the other side? You're looking for things that look out of place. You'd be surprised. I've had people tell me, they say, once the guy pointed it out to me, it was so painfully obvious, I would have seen that. I say, yeah, you would have if you got underneath the car and looked. So I tell people all the time, I say, climb underneath the car and look. And they go, I don't know what to look for. Yeah, you do. You look to make sure the engine's not leaking. Look to make sure the transmission's not leaking. And look for sheet metal and other things that look strange. Okay, things that look like they've been bent and straightened out. So, I'm convinced that the average person could spot most of this stuff if they simply put in the time before they bought the car. The problem is that most people are optimists when they're car shopping. And they think, I finally found the car I'm looking for. And they make that decision before they've inspected it or test driven it. So that's what you do if someone sold you a previously wrecked car. And I made it without coughing. You hear that though, right? Questions or comments, shoot them my way, lehtoslaw.com, LEHTOSLAW.com. I'm on Twitter at Steve Lehto, STEVELEHTO, and I'm on iTunes, Stitcher, SoundCloud, Podbean, Google Play, and YouTube. Thanks for watching. Thanks for listening. Bye-bye.